Oyez, oyez, oyez. All persons having business before this unbound tribunal of the Circuit and Superior Courts of the County of LaPorte and for the state of Indiana, you are now admonished to draw nigh and render your attention. This court now convenes with the Honorable Julianne Havens of LaPorte Circuit Court, presiding and allied by the Honorable J.D. Haas, LaPorte Superior Court Number 1, the Honorable Richard Stallberg, Jr., LaPorte Superior Court Number 2, the Honorable Jeffrey Thorne, LaPorte Superior Court Number 3, the Honorable Greta Freeman, LaPorte Superior Court Number 4, the Honorable Erica Stallworth, Magistrate of LaPorte Circuit Court, the Honorable John Link, Magistrate of LaPorte Circuit Court Number 4, and LaPorte Superior Court Number 4. In addition, we have retired Judge Stephen King, formerly of LaPorte Superior Court Number 2, as well as Senior Judge Nancy Gallagher, as well as the Honorable William Oakland, retired judge from LaPorte Superior Court Number 4. Please remain standing at this time for the entrance and presentation of our nation's colors by the Michigan City High School Junior ROTC Color Guard Unit, commanded by Major Thomas McGrath, assisted by Master Sergeant Jeff Bennett, and composed of Left Rifleman, Cadet Staff Sergeant Mercedes White, Marine Color Bearer, Cadet Staff Sergeant Aiden Gordon, National Color Bearer, Cadet Gunnery Sergeant Daniel Cohn, and Light Rifleman, Cadet Staff Sergeant Aiden Downs.
Order! Colors! Ready! Cut! Right, place! Present! Colors!
Please follow along as Judge Havens as she leads us in the recitation of our nation's Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Carry! Colors! Ready! Cut! Right turn! March! Forward! March!
Thank you, everyone. You may be seated.
Thank you for attending today. My name is Barb Stooksbury, and I'm the president of the LaPorte County Bar Association. Welcome the members of the bench, the bar, the LaPorte County community to the 2025 Law Day celebration. Law Day is an annual observance in the legal community for more than 60 years. It is a day in the legal community which celebrates the law and brings to life the role of students, the courts, and the Constitution in times of change. The 2025 Law Day theme is the Constitution's Promise. Out of many, one. The Constitution enshrines our collective responsibility to one another, and the 2025 Law Day theme urges us to take pride in a Constitution that bridges our differences to bring us together in a united nation. Our civic lives tie us together as one. We, whether through legislative efforts that serve the common good, through military service, or by working together every day to fulfill the promise of e pluribus unum, or out of many, one. At this time, we would like to honor those members of the bar that have gone before us this year. We honor the bar members who have passed since our last program last May. I asked Dave Surigo and Judge King to honor Magistrate Jonathan Forker and Attorney Larry Arness. We will start with Judge King honoring Attorney Larry Arness.
May it please the court.
Good morning to you all. It is nearly a year ago that Larry Arness passed away on May 15th, 2024. He was only 69. A week or so later, his family held a celebration of life at the Gary Aquatorium. That's an interesting building that sits on Oak Street with a panoramic view of Lake Michigan and Miller Beach, where Larry liked to camp overnight and hang out. It was a sunny spring day. The Chicago skyline gleamed on the Lake Michigan horizon, and it was truly a celebration of life that morning, for Larry was beloved by his family and friends. They told stories and they laughed about Larry and what he had meant in their lives. Larry was particularly proud of two nieces who had been on the Carmel, Indiana State Championship swim team. And they both spoke of Larry as part crazy uncle, part wise mentor. It was a heartfelt Larry love fest. Very special morning. Larry was born in Laredo, Texas. You know how Texans like to give nicknames to people like Bubba and Goober? Well, if Larry had grown up on the streets of Laredo, he would have been known as Slim, because he topped out at about 6'5", maybe 180 pounds. He was the walking definition of lanky. His family moved to Gary in the late 1950s. Larry grew up there and went on to IU and for his undergraduate degree, and he was there during the heyday of Bob Knight, who Larry came to revere despite the coach's sometimes dubious aspects. Isn't that politically correct? Larry liked his old school coaching techniques, and Larry liked to win. He went on to get his law degree at IU Indianapolis. At that time, an organization existed known as Northern Indiana Legal Services. It was managed by Kevin McGrath, a Michigan city attorney, who hired Larry and Jay Lauer, who happened to be a classmate of mine at Valpo, as staff attorneys. That bit of history is significant because Larry Arness, in terms of our local bar associations, was an outlier of sorts. He rarely appeared in LaPorte County courts, his family law practice taking him over to Lake and Porter counties. Still, from the start of his career with Kevin McGrath in the late 1970s through 2024, nearly 50 years, Larry maintained his membership in LaPorte County bar associations because he loved to ate like a horse, as they say, and because he loved the fellowship and good cheer of the gatherings. He relished talking sports, often kicking the IU-Purdue rivalry around with, who else? Allie Price. But he did more around here than just eat and talk. Larry had a 20-year affiliation with the Michigan City Human Rights Commission as a volunteer attorney. He taught law classes to offenders at the Lakeside Correctional Facility close by the Indiana State Prison. And for 23 years, he was on the board of the North Central Community Action Agency, which administers assistance to needy LaPorte County residents and those in the 7-county area. Consider representation of indigents, social justice, educating offenders, and assistance to the economically disadvantaged populace. Larry's legacy is quite a credit to our profession. But enough about Larry's good deeds. Larry was an action man. In his younger days, he took to cross-country motorcycle rides. Later, that gave way to a passion for bicycling. He often took on the tortuous Hilly 100 in Bloomington, Indiana, and routinely engaged extended 40 to 50-mile bike rides in the area. He kept track of his miles, and one day he ultimately reached the 100,000 miles on his bike. If you're daydreaming, let me say that again. He rode 100,000 miles on his bike. That alone should put him in the Bar Association Hall of Fame. But there is more. He was a hiker, a camper, a gardener, a chess player, a reader of books, a poker player. Above all, he loved sports. IU sports, Chicago sports, the Indianapolis 500. He was, as is common in our profession, a competitive person. So it was he came to organize some friendly $20 pools. One involved picking the winner of all the college football bowl games. And of course, for many years, he organized March Madness bracketology pools. Usually, that drew about 50 participants. Many of the most brilliant minds in our local bar association squandered their lunch money at the hands of Larry. For many years, I participated in a 10-team fantasy football league run by Larry, for which he held the lofty title of commissioner. Through those many seasons, Larry had never won the fantasy football league. But in the 2023-24 season, what would be his final season, Larry was crowned champion. We were happy for him because we liked him. As commissioner, he distributed the prize money to himself. 4 months later, he passed away. Well in advance of the next fantasy football season. I mentioned that in advance of the next fantasy football season because we have to acknowledge we have a situation here. That is, there is an unwritten rule in games of chance. That is, if you win a big pot, say in a game of poker, it is extremely bad form to rake in the winnings and immediately leave for home. It is expected, even demanded at the risk of physical harm, that you give the other players a reasonable chance to recover their losses. What we all learned in law school is that for any given rule, there is an exception. Well, let's call this the Larry Arness exception to that rule. And if you were in a situation where someone is trying to leave immediately after a big win, you can look them in the eye and cryptically say, maybe with a little Italian inflection, you don't seem to understand. Larry didn't do it that way. Larry would have liked that. He had a fine sense of humor. He lived life his way, and he made a lot of people happy along his road of life.
And now I announce Attorney Dave Sarugo to speak about Magistrate Jonathan Forker.
May it please the court. You're going to see a contrast between me and Judge King. When Barb Stooksbury asked me to speak about my friend, John Forker, I was honored to do so. I spoke at John's funeral, gave his eulogy there. That was 45 minutes. I've condensed it, but I'm going to give most of it what I said on that day. I can't remember exactly when I first met John, but his office was directly across the street from mine on Jefferson Avenue. I'm in the Masonic Temple building, and at that time his office was across the street. This is probably 1985, 86. And I remember my first two law cases. The first one was just the disperse of assets, dividing of assets. But these two people were professional or almost professional, semi-professional bowlers. And they each had purchased for their spouse a special bowling ball with their fingers drilled into that particular ball. And they would not give up the ball that they purchased for their spouse. So it ended up that the husband had the wife's ball, which he couldn't use except for a paperweight, and the wife ended up with husband's ball, which she couldn't use either. So that was my first experience with John Forker on the other side. The second was a change of custody. And there's nothing really strange about a change of custody case, except when John Forker and I are involved. John stood in front of his office. I stood in front of mine. His client next to him, my client next to me. John took the child by the hand and walked out into the middle of Jefferson Avenue. I walked out to the middle of Jefferson Avenue. John gave me the child's hand. We turned around and we walked, and I gave my client his child, and that was my first experience of change of custody. It was more like a prisoner swap that you see in the movies. Next day, I talked to John, and John said, "Welcome to family law in LaPorte." John schooled me in the practice of law in front of judges and in front of my own clients, like in a four-way conference, and he did it in such a way as not to embarrass me, and I've always appreciated that of him, not embarrassing a young lawyer, and I learned to do that myself, not embarrass a young lawyer. So after work, John and I sometimes went out to have a drink, and he would always have this green beer bottle, and it's called Rolling Rock. And Rolling Rock was made in Pennsylvania. Now, John was from New Jersey, but his family lived near Gettysburg, Pennsylvania, east side of Pennsylvania, and he was very proud of that state. And he drank that beer because it was from Pennsylvania. And later he introduced me to another beer from Pennsylvania called Yingling. Now, you can get it here now, but you couldn't get it back then around here. But when John went out east, or when his family came out west, John would bring back Yingling, and we would share this beer together that was special because you couldn't get it here. And then when my oldest son went to college, he just happened to go to Gettysburg College, and when I went out to see him, I came back with a mother load of Yingling and called up John, and we would share this special beer together. When early practice of law, John and I and the Honorable Judge King, we went on an infamous road trip to Indianapolis for a family law seminar. It was about qualified domestic relations order, or known as quadros. Boring, let me tell you. But we got through it. We had some fun while we were there. And on the way back, we stopped at a well-known bar outside Purdue in West Lafayette, just to get a burger and a beer. Let me step back for a moment. During this time in history, Reagan was president, Gorbachev was the head of the Soviet Union, or Russia, or whatever they called it at that time. But there was a gentleman in Poland that was leading the Solidarity movement. His name was Lech Walesa. And John loved to say his name. He would say, "Blah." And when John loved a name, he would stretch it out. He would say, "Blah." Okay. So that's just the way John was. So back to the bar in West Lafayette. So we're eating our lunch, and these younger people came up to us because we looked out of place in this bar. And they said, well, what are you guys doing here? Who are you? And instantaneously, John said, oh, we're with the band. We're just checking the place out. We're going to be playing this weekend. And, I think, oh, wow, cool. And then they asked us the name of the band. And instantaneously again, John, he was so smart and so funny, he said, well, we're Vlach and the Quadrotones. So he took Vlach Valesa, Quadro Seminar, put tones at the end, and that was the name of our band. He was brilliant, he was smart, he was funny, but he also was a scamp. He had a saying that I thought I was one of the few people that only knew this saying, and I have to modify it a little bit, but he always would say, a few beers, a few laughs, and maybe even a little hijinks. Now, I found out later that wasn't to be the case. At his funeral, many people came up to me and told me they knew that saying. John, Walter Jonathan Porker, nobody knew him as Walter, respected attorney, represented his clients well. He was well dressed, and he did a great job as an attorney for this bar. He became magistrate. He was a respected judge, made great decisions on the bench. He's what a lawyer should be, what a judge should be, a true professional. But during John's career, he had a special place he could call his home, away from home, and he didn't live too far from there, and that was I Street Bar, now known as JJ's Pizza Shack, for those of you who live in town here. He could go there by himself, he could be himself, and he could walk up to anybody and talk to them as if they were his best friend. You could be a plumber, you could be a teacher, you could be unemployed. That's what I loved about him. He was just a regular guy. He didn't think he was better because he was an attorney or because he was a judge. He was never that way. He was just John, our friend. Then John became ill, had to retire. I would visit John at his home from time to time, and I did that for a couple of reasons. One, to give Dara a break, because who cares for the caretaker? She needed to get out of the house. A lot of times that I visited him, we would Zoom with the grandchildren, and boy, he could be really without energy. But when those grandchildren came on the screen, it just brightened his day so much. It was just wonderful. Other times, John and I would just talk about nothing in particular. And then a lot of times we would watch the Civil War documentary by Ken Burns. You may have all seen it or heard about it. And John and I both liked it. Now, when we watched it, somehow we got stuck on the one episode about the Battle of Gettysburg because John loved Pennsylvania. So we were always back in Gettysburg. Now, in that documentary, there was a gentleman, a Southern historian, who has written several books on the Civil War. His name was Shelby Foote. He had a goatee. He spoke in a Southern drawl, and John just loved his name. And of course, like Blech, it became Shelby. And he just lowered his voice, and he just strung out that name. He just loved Shelby Foote on that show. Now, when I visited John, I never took a picture of him. I was more uncomfortable visiting John than John was with having me there. My friend was sick, and I was. So I never took a photograph while I was there, except once. John's bed was in the living room, and so when people came to see him, they could talk to him, and he'd be out there in the front living room and not in the back bedroom. And under his bed, he had several hats. And he was proud of this hat. Dave, I got to show you this hat. He put it on, and it was like an Indiana Jones hat, you know. And he smiled. And I asked him if I could take his picture. And he let me. And so, and I don't know if any of you can see this very well, but this is John Porker in his Indiana Jones hat with his Shelby foot goatee and a shirt that said 500. And I didn't know what 500 meant at the time, but I'm glad I took that picture, and I had forwarded it to several people. And Judge King responded to me, and he said, you can see the kindness in his eyes, and you can't. Later, Steve also told me that this should be John's album cover, and I couldn't agree more. It was an honor being John's friend, and John honored me in November of 23. He was getting sick, but he wanted to see his son married. CJ and his fiancee Shelley lived in Florida. They came up here, got a marriage license. Judge Alavizos made me Judge Pro Tem. Judge King provided me with his wedding vows that he used throughout his career as a judge. And John lent me his robe. And I performed that wedding ceremony so John could see his son get married. That was November 22nd, or 24th, 2023, at a well-known wedding venue here in LaPorte called JJ's Pizza Shack. Now, John was on hospice for 9 months, or over 9 months. That's got to be some kind of record. John was a fighter. He had bursts of energy. He wanted to be with us. He spent time with all of us. He loved us. When he would feel up to it, he'd go down to JJ's and have a beer. Might not stay for 5 or 10 minutes, but he went because he wanted to be there. Other times, you would go in there and see John, and he didn't even look like he was sick. He wanted to be with people. That photo I took of him, of John in his Indiana Jones hat and his Shelby foot goatee, I figured out what the 500 meant. That's how many friends Walter Jonathan Forker had at any one time in his life. And what more could you ask for? John, it was an honor to be your friend. You were loved by all. You'll be missed, but you will not be forgotten. Ever. How could we? You have a giant picture on the ceiling of JJ's Pizza Shack. John, we will all see you on the other side. And when we do, maybe, we'll have a few beers and a few laughs and maybe even a little heavenly hygiene. Thank you.
Thank you, Judge King and Attorney Cerugo. I move now to the keynote speaker, Senior Judge William Boakland. The Honorable Judge Boakland is our keynote speaker today. He was first appointed as a LaPorte County Superior Court 4 judge in 1993, elected in 1996, and re-elected in 2002 and 2008. He graduated from Purdue University with distinction in 1973 and received his Doctor of Jurisprudence from Valparaiso University in 1977. He was in private practice and served as a LaPorte County Deputy Prosecuting Attorney from 1977 until his appointment to the bench in 1993. He served as a senior judge after his retirement. And now he's our annual keynote speaker for Law Day. I announce Judge Boakland as our keynote speaker.
May it please the court. And thank you, Barb. It still works good. My program started off E pluribus unum, which is out of many one. And that's the theme for this year's Law Day. And as I got deeper and deeper into it, it started to mutate on its own. I'm a person who loves history and kind of enjoys watching politics and just watching things mutate and change. And minutiae, I love minutiae. Well, this thing is now the Alien Enemies Act of 1798. We all know that thing's in the news right now. And I could probably speak for 3 hours, but I was reminded today by a friend that brevity is next to godliness. So what I'm going to do, Barb, is when you think I should stop, I'll stop. You'll still get a program, but it goes in stages, so it is easy to stop. I also thought that the better title, as of this morning when I got out of the car, would be The History of the World Part 2, because it is that big of a story. Now, this particular statue was born in the second election of John Adams and Thomas Jefferson. And these two men had been as close as brothers throughout the Revolution in the early years. They worked together as ambassadors to Europe, and one was in France, one was in England, and they communicated constantly. But the second partisan election was the beginning of the crack in the unum, unum being one. We don't have a fixed one in this country. What we have is at least two, and oftentimes little splinters off of that. What really works about E pluribus unum is that we try for that, even with our differences. And these men were different from each other. This was destiny. John Adams believed in a strong national government and less powerful state governments that would be subservient to the national government. Jefferson was the opposite. He believed in more powerful state governments and less powerful national governments. Now, John Adams' philosophy reflected the culture of the area of the country he lived in. It was becoming mercantile and industrial. Building trades were starting to come up, and cities were starting to grow. And Adams believed that that was the future of America. He could see across the country as America would grow, and he said, that's what we're going to find. In some ways, he was right. And the geography and climate of where he lived did not lend themselves to large plantations or long growing seasons. But small farms with short growth products worked pretty well. Jefferson, on the other hand, was a product of the philosophy of his culture in the South. It was an agrarian economy with huge plantations. And most of the time, those plantations were tobacco plantations. And most people don't know, but tobacco just destroys the earth as it grows. And so they'd have to cycle the growing areas around that to allow the land to recover. These people who benefited from it had extravagant homes, and the benefits of their wealth and production went right to the top of that culture. It wasn't spread out either. Now, they had slavery in New England early on, but it evolved away, not because of any moral thing, but because it just wasn't economically feasible to do it. And those people who did have slaves in those states had only one or two, and they usually lived in the household with the family. And it's kind of hard to look at a person who's living in your house and you see every day personally and think of them as something other than a human being. And a lot of the masters were actually teaching trades to their slaves who they would later free, and they'd be able to operate with the trade. And John Adams was what they used to call in the 1990s WYSIWYG. What you see is what you get. There was no pretense for this man. He was irascible. Most people hated him. He was a bully at times. If he got on top of a fellow lawyer, he let him know it the whole way through. Jefferson, though, saw slavery as the only way to support the economy and culture of the South. He once said, "We have the wolf by the ear, and if we let him go, we can't let him go, and we can't hold on to him." Now, they should let him go, free the slaves, but they couldn't and survive, and he knew that. And Thomas Jefferson's personal life was very different from the life of John Adams. It was really intricate. He had a concubine after his wife died. He fathered, I think, 13 or 14 children, most of them with the concubine. And he was very secretive about his life. He knew as a politician this wasn't going to work, so he never said anything. And most of the people who researched Jefferson have no idea about his personal life, but they do know what DNA says. And that would have been the 90s and 2000s when they could establish his second family. By the time of this second partisan election, these men hated each other. They wanted to destroy each other. And the Alien and Sedition Acts, the Alien Enemies Act that we see being used now, was born among this turmoil. The Federalist Congress enacted this during a thing called the Quasi-War. And it was against France. It was 2 years in duration. It was mostly fought on the seas, in the Caribbean Sea or in coastal portions of the United States. And it was mostly, if not totally, a naval war. And they only were fighting because the French were taking sailors from America's Navy and impressing them into working for the French Navy. And they were sinking our ships and stealing ships with all the sailors aboard. This war was never declared. And the stated reason for enacting the laws at the time was to stop French spies and sympathizers from infiltrating the country. Wouldn't seem like much today, but then it would, because France was in turmoil and people were leaving as fast as they could because they didn't know what was going to happen. And when they got here, they tended to vote for the Democratic Republicans rather than the Federalists, and John Adams was a Federalist. Now, the Alien and Sedition Acts had 4 parts: Naturalization Act, which raised the residency for citizenship and voting from 5 years residence to 14 years residence. And that would disenfranchise a good many of Jefferson's voters. The Alien Friends Act is so mislabeled. It provided that the president could deport or imprison any alien deemed dangerous to national security, even during peacetime. So if he didn't like you, you could be deported. The Alien Enemies Act, the president could detain or deport aliens from a nation at war with the United States. And the Sedition Act criminalized false or malicious statements about the government. The real tricky part here is or malicious, because it could be a true statement, but if it harmed the government, you could be punished for it. Well, the Democrat-Republicans, who I call DRs for convenience, they claim that this act had no other purpose than to try to disenfranchise their voters. And it was nothing but an attempt to sway the election in favor of the Federalists. Now, Jefferson and Madison responded to it, oddly, because judicial review, we know that most of the time, and we see it today with cases, they're going up and they're going toward the Supreme Court, which is the ultimate arbiter of the decisions in these cases. It wasn't that way then. That wouldn't be until 1803. So they drafted and got passed the Kentucky and Virginia resolutions. And they introduced with these a thing called state nullification. And that meant it might be okay in 12 states or 11 states, but it's not in our states. We're not going to enforce this law. And if you can imagine what a mess we would have if that became a method of determining constitutionality. And just for good measure, Thomas Jefferson hired a publisher named James T. Callender. And James Callender was, when I first tried to describe him, I could hardly do it without profanity. But he was a muckraker for hire. He would say or write anything about anyone if he was paid enough. He would write defamatory things about his mother if someone gave him enough money. And he wrote that John Adams was mentally deranged and planning to crown himself king and grooming John Quincy, his son, as heir to the throne. He also said Adams was a hideous, hermaphroditical character, which has neither the force of a man nor the gentleness and sensibility of a woman. Now, we would look at that in the political campaign today and go, what? Then it meant something. They were shocked by it. And just like today, there are any number of people who will vote who don't pay attention to reality. And it worked. Jefferson's strategy worked. And John Adams lost the presidency. And with the presidency, they lost Congress as well. So the DRs had a majority of everything. However, as luck would have it, Jefferson received 73 electoral votes, but so did his running mate, Aaron Burr. And everybody knew that Burr was running as the number 2 guy, but there was nothing in the law that said if he got one more vote than Jefferson, he would become the president. So he could have become the president. And this was thrown into the House of Representatives. I'm not sure if we ever had another election that got thrown into the House. 36 rounds of voting, and no winner was declared in 35. And finally, the election was tipped by Alexander Hamilton. We've heard the name, but we don't know, most of us, what he was like. He was the highest of the high Federalists. He probably would have been happy with a monarchist, as a monarchist, with a king. But he said Thomas Jefferson is terrible, but Aaron Burr is horrible, much worse. So he got one person to cast a vote for Jefferson, and he became president. Now, after the acts came up, and they came to be reviewed by the DR Congress, and the Alien Friends Act expired of its own terms. If that wasn't put there to tip the election, I don't know what else would say that. We can do anything, throw anyone out, but only until 1800. And the same happened with the Sedition Act. It expired in 1800s. And John Adams, as well as WYSIWYG, was well known for being very, very sensitive to criticism. And so it didn't matter once he got reelected, but he didn't. The Naturalization Act was repealed by the DR Congress, and the voting age went back from 14 years here, or 14 years in this country, back to 5. And all those people now were reenfranchised. But this one stays, and it's here today. The Alien Enemies Act could detain or deport aliens from a nation at war with the United States. And we're left with questions. What constitutes a war? What constitutes a nation? That one, I think, was just resolved in a federal court yesterday. That there was an effort to make a drug cartel declare it to be a nation. And that judge said, that's not a nation. And this isn't a war. And finally, what constitutes a predatory incursion? And I'll get to why that's important. Now, it was established law in the United States regarding aliens and due process. It is undisputed, and this is from a World War II case that has not been reversed. It is undisputed that in peacetime, an alien is protected by the Due Process Clause of the Fifth Amendment. And that was from a case called Wing Wong versus United States, decided in 1896. So this is a long-standing law. They are protected by the Due Process Clause. And the Alien Enemies Act, up till now, has only been used 3 times. So this is I compared it to the story Brigadoon, with the town that pops up every 100 years or so and then goes away. That's what this is. Unlike most law, this thing has hardly been touched through most of our history in terms of interpretation. It was used in the War of 1812. It was used in World War I and in World War II. And each of those wars had 2 things in common that are different from today. The first one is each one of those was a congressionally declared war. And most people don't know, it's in the Constitution that Congress declares war, not the president. In the Vietnam era, there were some laws passed, I think an amendment, that allowed the president to kind of declare war for a period of 45 days and then have to do it again. But at the original Constitution didn't provide that. And all 3 of those wars, the United States was fighting for its very existence in the world. These were people who were hoping to survive the war. The Alien Enemies Act has never been used before today without a declaration of war. Now, the War of 1812 seemed pretty simple, but in 1813, this guy here, who was his name was Bushrod Washington. And Bushrod was a nephew of George Washington. He was also a Supreme Court justice, and in those days, they didn't just get to stay there in the Capitol and hear appeals. They had to ride circuit. And he had a case as a judge riding circuit. And he looked at the statute that comes down out of the Alien Enemies Act. And he split it. In his mind, he said there are 4 sections now. There were 3 then. But he split section 21 and 23. And in section 21, he said, section 21 only applies to the presidential edicts, and nobody can go against those things. There's very limited due process that's allowed anybody who's arrested and prosecuted under that. And if you watch the news and you see every now and then people just being loaded up and sent away, that is a presidential proclamation. Section 23, though, applies to a citizen complaint. And that would be if any one of you knew you had an enemy alien living in your neighborhood. And so you went down to the courthouse and filed an action. And then they would get the full rights of anybody in the country during their trial. The appeal today would be under a thing called the Administrative Procedure Act, and you can challenge in that context any issue pertaining to it, the deportation. However, under Section 21, Bushrod said habeas corpus is the only thing. Now, even to attorneys, habeas corpus is a mysterious concept. I can't give you a definition. I've never had to do it, never had to hear it, but I think it's basically just throwing everything but the kitchen sink at an issue and hoping that it gets clear. In this context, though, it means, do you fit the facts? that are causing people to get deported. At some point during World War I, this statute, I mentioned this already, was codified into Title 50, War and National Defense, Chapter 3, Alien Enemies, and it went from 3 sections to 4 sections. Most of the time that doesn't mean a thing. That's just to try to make it easier to read. And during World War I, courts read this statute to say that Section 21 gave the president unrestricted authority to remove alien enemies. That means he could do whatever he wanted. He could send off whoever as long as they fit the profile. There was no right to judicial review other than habeas corpus. Now, World War I, as any of us who are old enough remember from grade school, ended November 11, 1918. 11/11 at 11 o'clock. In 1920, the Congress of the United States passed a bill that required all aliens to be given a fair hearing before deportation. And it wasn't until the end of 1920 that President Wilson declared the war over. I never knew that. I always thought when the fighting stopped, the war was over. But the war isn't over until the president says it's over in a declared war. And that's when Section 21 and deportation process stopped, and aliens would have their regular rights like anyone else. World War II brought on some interesting cases. And I think probably the most interesting, even factually, is the case of the United States versus a man named Herman Schlater. Herman was born in Germany in 1915. And these are findings of fact in the case. Came to America in 1929, and he was steadily employed as a lunch counter waiter and a bartender in Queens. You did the math, didn't you? He was a 14-year-old bartender. Apparently it was okay. In 1933, he made a mistake, and he joined an organization called the Friends of New Germany. And it later became known as the German-American Bund. And there was a big concern about this organization during the 30s and into the early 40s with it because of its fascist tendency. That first picture here, this is a parade in New York City in the 30s. And you can see all the American flags. And then you see this one tucked away on the other side, a Nazi swastika. Well, I think this is what got Herman in trouble. On July 31, 1942, he was arrested and interned as an alien enemy. And while he was sitting in jail, he asked if he could be transferred out west and work in the Forest Service because he thought, I can do something positive if you let me do it. And they did it. They let him go out west. And surprisingly, made no attempt to escape. He worked, and they said he was a good worker. And after he was released from the Forest Service, he was returned to New York City. And in September of 1945, he was paroled so he could work in a war essential industry. But at the time of his reinternment, Germany had already surrendered. So his big threat to them was Germany. He was a German citizen. He always had been. And Germany had surrendered, and the Allies were in charge of the country of Germany. But the war with Japan was still going on. And Schlater had declined to fight against Germany, but he volunteered to fight against Japan. So there you have a little profile of this person. In the New York trial court decision that was published in the Federal Supplement, I've taken some text verbatim, and all I've done is add bracketed information because they're using the legal terms rather than names. This was contained in, quote, I'm quoting exactly. Schlater was given hearings before hearing boards at different times and places. At each of said hearings, he was advised by representatives of the Attorney General that he had no right to be represented by counsel, was not informed of the charges against him. He was not confronted with witnesses, and he was not allowed to examine or cross-examine any witnesses. This is a quite foreign version of our legal system, but that was upheld. They went on to say hearing boards based their judgment on hearsay or incompetent evidence. And the Attorney General alone knew the charges. He didn't even know what he was being accused of. And the Attorney General heard the testimony. And the Attorney General decided upon Schlater's internment and removal from the United States. And I don't know, I've been close to this case for a while, and the question comes up, if that is all that is true, what's the purpose of the hearing board? And I can't find it in black and white, but I'm pretty sure it was just to comply with the law passed after World War I that required fair hearings. That was the definition of a fair hearing for an enemy alien. As you might have guessed, this case was appealed, and it was affirmed by the Court of Appeals. And it went to the United States Supreme Court after that, and Justice Felix Frankfurter wrote the majority opinion for a 5-4 split. And I'm sure anybody who remembers their law school days remembers the name Felix Frankfurter. He was a well-respected judge and justice. He said Section 21 gave President Truman summary power to order the removal. Now we're not even talking about a hearing. In his opinion, Frankfurter appears to have ignored the provisions of Section 23 entirely. And Section 23 is what brings the courts into the process. He just shoved them aside. They weren't part of it. It was following the Bushrod Washington idea that the government institutes it, it's entirely the president. If your next door neighbor starts it, then you get to go to court. And the majority of the Supreme Court found that he had no right to judicial intervention or review, and there was none in that statute. That was Section 21. And the only power for review is in the statute 2 down. Frankfurter went on to say, it is not for us to question a belief by the president. And it's important, most of us have never lived, all of us have never lived in the time of a declared war. But when the Congress declares war, what they're saying is, Mr. President, you are the commander-in-chief. You know what the problems are that we're facing. You decide what constitutes an offense. And that was the way it was read. That alien enemies deemed fit subjects for internment during active hostilities do not lose their potency for mischief during the period of confusion and conflict which is characteristic in a state of war. That's Frankfurter with his eloquence saying that, hey, just because Germany surrendered doesn't mean this guy can't cause trouble. And he said, even while the guns are silent. And that's what it was. Now, World War II was declared ended December 31, 1946. That's well after Germany had surrendered and after the violence and the fighting with Japan had ceased. And this opinion appears to be valid authority at this time. So if you can comprehend what I'm telling you here, you understand why some orders can come out and they have to be tested in the courts. How am I doing? Okay. 227 years later, the Alien Enemies Act rears its ugly head again. And this time it's raised, and the statute says whenever there is a declared war between the United States and any foreign nation or government. That one, the administration knows doesn't apply. But any invasion or predatory incursion by any foreign nation or government is what the president has hung his hat on, and it appears to fit. It did at least until yesterday, and we have a federal trial court in Texas that said this is not an enemy incursion. These are people trying to get out of their country. They may be affiliated with a gang, but it's not the government that's sending them here. We'll see if that holds, because that'll go up through the Court of Appeals to the Supreme Court. The president has to make a public proclamation of the event under this law, and he did. Section 21 of the statute provides the subjects of the hostile nation or government being of the age of 14 years and upward, living in the United States, and who are not actually naturalized. There's your target group, right there. These are people who are coming from a hostile nation, and at least 14, maybe older. They're living here, not citizens, because they've never been naturalized. And these people shall be liable to be apprehended, restrained, secured, and removed as alien enemies. Now, President Trump's proclamation raised a bunch of issues that are questions of fact. Tren de Aragua, I never get this right. This is the drug cartel. I'll call them TDA as is a designated foreign terrorist organization under 8 U.S.C. 1189. That happened very recently. I think the Secretary of Defense did that. But this is the enemy nation or government. At least that's how it's been understood. And one of the questions that this case that I'm talking about from yesterday is going to raise is, can a president create a nation or government with a presidential proclamation? Now, he's not really creating a nation, but he's creating the equivalence of a nation that has power to send people and fight and all that. It's all a question of fact. It said they operate out of Venezuela, perhaps with the cooperation of the government. I look at this and I say, this is a question of fact. Somebody has to prove this along the way for this to take place. They have infiltrated the United States. I would think that a hearing officer would want to see some evidence of that. Have perpetuated irregular warfare against the United States. I don't know, I don't have any idea what irregular warfare is. I'm sure there is such a thing, especially now in the age of technology, but it's a question of fact. Now, the text from the president's proclamation also recited his theory of defensiveness. He said, by the authority vested in me by the Constitution, blah, 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 including 50 U.S.C. 21 et sec. Well, et sec means 22, 23, and 24 as well. And that brings in the paragraph about the judiciary. All Venezuelan citizens, 14 years of age or older, who are members of TDA within the United States, are not actually naturalized. All of these things are questions of fact, I would think, that could be reviewed in a habeas corpus petition or a process that allows for appeal. Are liable to be apprehended, restrained, secured, and removed as alien enemies. And then he goes on to say, I find, by virtue of their membership in that organization, they're chargeable with actual hostility and ineligible for the benefits of Section 22. The benefits of Section 22 are that if you are not chargeable with actual hostility and have not committed another crime, what it makes you is a status offender. You are here. You haven't done anything wrong, so you probably should be allowed a more fair time to absent yourself. Now, he shall be allowed time for the recovery, disposal, and removal of his goods and effects, and for his departure. And everybody who owns a television or an iPod or whatever, has seen the guys being marched off, bent over in their underwear, that were put on a plane and sent down to El Salvador, which is kind of odd to me because that's not even the country they came from. But if they hadn't been treated as guilty of actual hostility, they would have had a right under this statute to take the time it needed to move. And anybody here who's moved a law office or moved a kid to college or moved from your home to another knows that's not going to happen overnight. It takes time to get your affairs in line. Now, to determine the whole amount of time, what time they get that's fair, it shall be stipulated by any treaty then in force. I don't think I'm wrong in concluding that there is no treaty with TDA, the drug cartel. But I know there's a treaty with Venezuela. I haven't read it. I don't know if there's anything about exchange of prisoners or citizens. And if that's not enough, where there is no treaty, the president may ascertain and declare such reasonable time as may be consistent with the public safety, according to the dictates of humanity and national hospitality. I don't really know what they mean. Maybe there's something out there that would show us. But I don't think this is humanity and national hospitality. You can disagree if you like. That's what America's for, right? We don't all have to agree. Now the big one. I haven't told you what the role of the courts is yet, have I? Well, after any such proclamation has been made, upon complaint against any alien, it shall be the duty of the courts to review it, to order the alien to be apprehended, to be conveyed before such court, judge, or justice, and after a full examination and hearing, and sufficient cause appearing at the hearing, that person can be removed. And lawyers among us here, you know what I just recited was pretty much the legal process. It may not be as extensive as some people would like, but at least you get your day in court and a neutral makes that decision. Now the courts have a lot of options. They can order the alien removed, order the alien to give sureties for his continued residence, meaning I will behave, I won't associate with whoever it is you're worried about, or you'll take my house, or otherwise restrained. And I'm not sure when this was written, they certainly didn't have electronic monitors or data recording or any of the stuff that we have now. And prison is one of the options. And it's to be used when someone will be deported based upon the evidence. Section 23 of the statute provides the only mechanism to review the process, but it appears to have never been used for cases that were initiated by a president. We'll see if they've been right or if maybe it should have been used. This will come probably within the next year. It'll become right, make its way up to the Supreme Court, and we'll find out. Thank you for listening to me. If anybody has a question, I'd be happy to answer, and if you'd like me to shut up, I will. Okay, good. Thank you. Yeah.
At this time, we will be presenting the Liberty Bell Award. The LaPorte County Bar Association also selects a recipient of the Liberty Bell Award, and it's given to a resident of LaPorte County who has promoted a better understanding of the rule of law, encouraged a greater respect for law and the courts, stimulated a sense of civic responsibility, and contributed to good government in our community. Although no formal prohibition exists against giving it to an attorney that practices in LaPorte County, we typically nominate a layperson in our community who satisfy the previously outlined criteria. This year, Atlee Price nominated our recipient, Lisa Prusakowski, and he will present the award to you and also say some words.
Thank you, Barb. You've all got programs and you can read about all of the things that Lisa has accomplished to come to where she is today, I believe now 10 years after you took office originally. Is that correct? 11 years. That bio is complete. I urge you to reference it, but I find a lot of people always asking me, well, what the hell exactly is a township trustee? Well, I can tell you because I've represented him back in a prior point of my career when I was a defense attorney and in general practice, that from the largest one in the county, the Michigan Township Trustee, all the way to one of the smaller one or two in very small rural townships in the southern part of the county, it's quite diverse. Down there, south of 30, it consists of basically fence and boundary disputes and to stray animals, compared to Michigan Township, where it ranges to handling utility shutoffs for people, emergency housing when they're put on the street, or even arranging funerals for the destitute. But the biggest thing that most of us, I think a lot of us, take for granted or aren't even aware of is that throughout the state, the township trustee is responsible in unincorporated areas of managing and ensuring adequate fire protection through volunteer fire departments. Equipment, training, raising the funds, and making sure that's accomplished. And how does that affect us? Well, if you own a home, I guarantee you it affects you, because it affects your insurance rating and what you pay in the way of premiums. Our Center Township Volunteer Fire Department, in full disclosure, I live in Center Township just by a few inches, because I'm right on the line with Springfield Township, but I've had occasion to have interactions with our volunteer fire department, and they are true professionals, wonderful people. We now have what I consider to be state-of-the-art coverage in a brand new fire department that Lisa led the charge and spearheaded on getting built north of the toll road on Johnson Road. And she went one step further. One area that was kind of a pet peeve for me, she agreed upon as well. 400 West and its intersection with Johnson Road, right at the peak of the toll road, was one of the most dangerous intersections in the county. There have been numerous fatalities over the past several decades. And finally, our commissioners listened and they altered that highway intersection with Johnson Road with 400 West, and it's now some distance away. And that affects your fire coverage as well because of the amount of distance they have to travel to respond to calls. But the most important aspect that we find being rendered by most township trustees is providing assistance to the needy. And it is indeed their most important function, and the one that I think Lisa takes the most pride and importance in. Before I expand on that, let me explain something, though, about Lisa's appearance here today. First, I think there are two records being set. One is that, and I'm not entirely sure of this, but she's got to be among of the probably 50 or more recipients that have received Liberty Bell Award, that once she was advised that she was the recipient, she actually changed her vacation plans so she could be here today. Otherwise, she'd be in Tennessee right now on a mountaintop somewhere. And second, I would bet money on that she does, in fact, hold the record of doing something that no other Liberty Bell recipient, at least in this county, has been called upon to accomplish. And that is, until Wednesday afternoon of this week, she spent 3 days sitting right there in that third chair that Magistrate Gettinger was sitting in, because she was selected as a juror in a sexual assault trial that was held in this courtroom. And it took 3 days. And I remember talking to Lisa when I called her and said, hey, we had a meeting of the Bar Association. We're going to give you the Liberty Bell Award. And she said, well, I thought you were calling me about, this is prior to the trial, I thought you were calling back because I got this notice to jury duty. Am I going to have to show up for that? How can I get out of it? I said, well, listen, don't worry about that, all right? I said, we called 70 people, and the odds or likelihood of you getting picked, very, very slim, all right? I wouldn't worry about it. So lo and behold, after the first pass, and she's not stricken for a cause or a preemptory challenge. Both lawyers were very impressed by her, obviously. The judge announced from the bench, all right, those of you left, you're on the jury. If the phrase
burning a dagger through you has any meaning whatsoever. That was the look I was getting. But she did her duty and served and played a very important role in that aspect. You know, we know all of us are familiar with people like Mother Teresa, Nelson Mandela, Mahatma Gandhi, Desmond Tutu, and those are all world-class humanitarians, certainly. They affect the societal weave of the fabric of our nation, and I would liken it to a masterpiece tapestry that we might see in the Louvre. But on our local horizon-to-horizon existence here in LaPorte County, our societal weave of fabric, I often think, is impacted more, and it's akin more, I think, to the mosaic that we would see at a local art fair. And it would consist of volunteer teachers, Alcoholics Anonymous, Al-Anon Anonymous sponsors, soup kitchen workers, clothing bank operators, and also fervently committed township trustees like Lisa Pierce-Kowski. Look, folks, you know, none of us want to admit it, but we're all only one blink away from debilitation because of being involved in a catastrophic car crash. There's no question about that. Some of us this very minute, we may not know it, but we're in the penumbra of a medical diagnosis that will define the limit of our existence. Each of us are truly clueless to the reality of fate. We spurn the possibility of us or a loved one being plagued by addiction to drugs, alcohol, or gambling. The prospect of succumbing to mental illness is not in our grand scheme of anything. We assure ourselves that the roulette wheel of falling victim to criminal misconduct or meteorological mishap is never going to land on our number. But indeed, statistics now today show that close to 20% of us are one paycheck away from being homeless. By the way, we have local legislators that want to make that a criminal act. So the panaplias of those assorted misfortunes I've just described, they actually occur right here in Center Township every day. And they can be likened, I think, to a pack of roving wolves that are perpetually kept at bay or away from our doorsteps because of people like Lisa Pierce-Kowski. She certainly personifies Pearl S. Buck's declaration that the barometer of the health of a civilization is the way in which it cares for its most helpless members. With that, Lisa, I would ask you to please come forward and do us the honor of accepting this year's Liberty Bell Award. Ladies, if you'll make that presentation.
First of all, I'd like to thank my husband for being here with me today, for my staff. I couldn't do half of this without them. To Atlee for making the nomination, for all the judges, lawyers, prosecutors, everybody that I've worked with over the years. I appreciate each and every one of you. I came into this court for the first time ever about 30 years ago and sat back there and watched a person go through, and when they were taken away to prison, I felt relief. Then I was in this courtroom 2 times, sat there one time to testify, and Judge Alavisos, the prosecutor, kept questioning me and asking me, and like wanting me to change my story, and I was like confused, and the judge says, "Do you know who you're talking to?" And I was like, uh-oh, somebody's in trouble. And I thought it was me. And he goes, "Do you know what she's done for this community? You're not going to get her to change her story. She came here on her own to help this young man get into drug rehab." And that, right then and there, made me feel really good about what I was doing. and that's something I continue to do. Then, this week, I sat right over there. First time ever I've been a juror. And I will tell you, it's not something that I ever want to do again. I will tell you, it's not something I'm comfortable with the decision that was made, but because what was presented to us by the judges and told what we had to do, that decision was made. But it was very difficult. So today, I thank each and every one of you for this award. It's an honor to be here. It's an honor to receive this award. But I think each and every one of you deserve the award just as much. So thank you.
I would like to thank Judge Havens and her staff, Atlee Price, Paige Struss, and the rest, for hosting this year's Law Day, as well as their assistance in preparing and planning for this event. Also, thank you to Secretary of the LaPorte County Bar Association, Tara Wordley, for your assistance in planning the event. And to all the attendants, the LaPorte County Bar appreciates your attendance here today, and we hope to see you here next week. And congratulations, Lisa. Judge?
All rise.
Court is now adjourned. Thank you for attending.
God save the United States of this honorable tribunal. This court is now declared adjourned.